Good evening, ladies and gentlemen. Welcome to this webinar on cross-border insolvency. Should India adopt UNCITRAL model law? My name is Gaurav Banerjee. I'm speaking to you in my capacity as the Vice Chair of the UNCCI, which is the UNCITRAL National Coordination Committee for India, and our chairman is Mr. Fali Nariman. And our mandate is to capacity build in topics of interest to UNCITRAL. And as you know, UNCITRAL is the United Nations Commission on International Trade Law. And interestingly, India was a founder member. And this is the fourth in our series of webinars. And at this stage, I must thank our mentor, Mr. Ajay Thomas, who's the director of Manav Rachna University, without whom none of us would have been here and none of this would have happened. So thank you, Ajay. So let me tell you a little bit about the topic. I'm obviously not going to reveal all that is to be revealed by the speakers. In India, particularly in respect of the IBC 2016, we've heard all these new terms like resolution applicant, resolution professional, financial creditors, etc. And there's been a lot of noise and lots of judgments on the IBC. But the topic that we are discussing today, cross-border insolvency, hasn't really come to the fore. And this is an opportunity to learn a little bit more about it. Obviously, there is a great deal of relevance to this topic. There are companies, Indian companies operating abroad. There are foreign companies operating in India. There are creditors abroad. So how do we resolve problems when some of these companies go insolvent? What is the process? What about parallel proceedings? How do we solve these problems? These are some of the issues which will be addressed by your very distinguished panel of speakers. So far as UNCITRAL is concerned, it has come out with a model law in 1997. I understand that there are 46 odd states which have signed on to it. The IBC, as I mentioned, didn't have this initially. There was a report of the Insolvency Law Committee, which made some recommendations in October 2018. I'm not going to tell you much about what it said because we have the privilege of having Dr. P.K. Vishwanathan, one of the members of that committee, and I'm sure he will shed some light on it. There is another committee which is presently there, which is the KP Krishnan committee, and again, I'm not going to tell you much about it because lo and behold, we have Aparna Ravi, one of our moderators, who is on the committee, so we will find out more about it. But parallelly to all this, the law is not stagnant, and despite there not being any clear law on cross-border insolvency, we have had cases in the courts, and we've had the case of Jet Airways. And again, and this is something quite special, we have with us Mr. Sumant Batra, who was an expert on insolvency, and he appeared in the Jet Airways case, and we'll hear from him as to how that worked out in the absence of the UNCITRAL model law. And of course, we have other cases like Videocon, etc. So this is a very much a live topic. And to discuss this topic, we have for you 4 stellar speakers. I must say, I mean, it's a very, very distinguished panel. And let me tell you a little bit about each of the 4 speakers and introduce them to you. Our first speaker will be Kate Lannon, who is a senior legal officer at the UNCITRAL Secretariat. She is in charge now of she's responsible for insolvency issues, but she's had a very varied career. She's been a corporate litigator. She has qualifications in both common law and civil traditions. She has been a diplomat. She's worked with the World Health Organization, and obviously she knows a lot about insolvency and cross-border insolvency, and she'll be giving us her perspective on it. Our second speaker really needs no introduction to an Indian audience, and that is Dr. T.K. Vishwanathan, who I had the privilege of first meeting when he was in the law ministry and he was the law secretary. And I've known him since then. Obviously, he's gone on to bigger and better things and great achievements. So far as this particular topic is concerned, he was the chairman of the Bankruptcy Law Reforms Committee, which set up the IVC. So he's a domain expert. As I mentioned earlier, he's already been on one of the committees which has considered cross-border insolvency. If I was to spend the next hour, I could go through his CV. I mean, it is glittering with achievements. He was awarded the Padma Shri not so long ago. He's been law secretary. He's been Secretary General of the Lok Sabha. But I mean, quite apart from that, he's just a wonderful human being. Our third speaker is, of course, Sumant Batra, who is a partner in Kesar Das Associates. That really doesn't tell you anything about him at all, except if I was to describe him in just 2 words, he would be Mr. Insolvency. He was an expert in insolvency. He's an expert in insolvency, and he has been studying this from the time when insolvency was not a sexy topic. I mean, he's been doing this for 20 years. He's been a president of Insol International. He's got an international reputation. He's worked with the IMF, the World Bank, the OECD. I mean, the list goes on and on. He's a friend of mine, of course. That's something I treasure a lot. He teaches, but I think what will be interesting is to find out his point of view, particularly, you know, about Jet Airways, where he participated, and he's had a lot of practical experience as well. Our fourth speaker, very distinguished judge of retired from the Southern District of New York, bankruptcy judge. You would realize, of course, you know, Chapter 11 bankruptcies in New York. You can understand the stakes involved. He did that for 15 years. He's got a fabulous sort of background. Yale and Harvard Law School. He was a top-ranked litigator. You've all heard of White and Case. He teaches, and of course he represents the US when he's part of the delegation which goes to UNCITRAL. So he's actually seen how this model law works. So those are our 4 speakers. We have unusually distinguished moderators as well. We have 2 co-moderators. I mentioned Aparna Ravi tangentially when I was talking about the topic. Aparna is a partner at Samvad Partners. She's had varied experience. She's worked in London. She's worked in New York. She worked in an investment bank in London. She is part of the Bankruptcy Law Reform Committee, which is ongoing. So obviously she has tremendous expert knowledge. She is an author as well. She's edited Mullah on Insolvency, which was published by LexisNexis, which is the locus classicus on the subject. And we are very fortunate to have her as one of our co-moderators. Our other co-moderator, of course, is Advaita, the secretary of the UNCCI, and she really needs no introduction. She's got a wide and varied practice, and we will hear more from Advaita, of course, in the course of this webinar. So before I hand over finally to Athita, who is the head of UNCITRAL RCAP, I just want to thank UNCITRAL and UNCITRAL RCAP for lending their weight to this webinar, and I'm sure this will work out, and this will be something we will all treasure. Thank you very much. Athita, over to you.
Thank you very much, Gaurav, and greetings to our distinguished speakers, co-moderators, and webinar participants from near and far. I'm Athena Kominder, and I head the United Nations Commission on International Trade Law, Regional Center for Asia and the Pacific, located in Incheon, Republic of Korea, or UNCITRAL RCAP. I am honored to deliver co-welcoming remarks on the occasion of UNCITRAL RCAP's first digital event on cross-border insolvency. UNCITRAL and RCAP extend special thanks to our partners, the UNCITRAL National Coordination Committee for India, UNCCI, and the Center of Excellence on ADR at the Faculty of Law, Manav Rachna University, and our co-moderators, Gaurav, Aparna, and Advaita. I extend my gratitude also to Director Ajay Thomas and Judge Alan Gropper, who worked across the international date line several days to help us overcome some technological complications, in addition to lending their legal expertise to make today's event possible. As some of you may know, UNCITRAL RCAP is UNCITRAL's only regional center. We've opened our doors since 2012 with the generous support of the Republic of Korea, and work with our colleagues at UNCITRAL headquarters in Vienna to promote the progressive harmonization and modernization of international trade law in the Asia-Pacific region. In so doing, we assist governments and stakeholders in overcoming disparities in national legal systems, thereby facilitating cross-border commerce and international trade. In addition to insolvency, UNCITRAL's current work program covers access to justice via mediation and arbitration, judicial sale of ships, creating a legally enabling environment for micro, small, and medium-sized enterprises, and e-commerce and the digital economy. Today's focus on cross-border insolvency is especially timely. As COVID-19 continues to disrupt global trade, the need for harmonization has become more pressing than ever. By way of background, while the number of cross-border insolvency cases has increased significantly since the 1990s, the adoption of national or international legal regimes equipped to address the issues raised by those cases has not kept pace. The lack of such regimes has often resulted in inadequate and uncoordinated approaches to cross-border insolvency that are not only unpredictable and time-consuming in their application, but also lacking transparency and the necessary tools to address the disparities. One of my colleagues joining us from Vienna, Senior Legal Officer Kate Lannon, will thus be providing an overview of the UNCITRAL model law on cross-border insolvency and its main advantages and other related dimensions. I also look forward to the expert presentations by Dr. T.K. Vishwanathan, Mr. Suman Patra, and Judge Alan Gropper, and wish everyone here a very successful webinar. Thank you very much.
Thank you very much, Atita. I'd also like to thank Mr. Gaurav Banerjee for his excellent introduction to today's session, as well as his kind remarks on all the speakers. Today's topic deals with a very significant gap that currently exists in the Indian insolvency regime, which is the absence of any sort of comprehensive provisions to deal with insolvencies that have implications across national borders. And this gap was noticed by the Joint Parliamentary Committee at the time that it was reviewing the Insolvency and Bankruptcy Bill of 2016. And at that time, the committee did note that the implications of cross-border insolvency cannot be ignored for long if India is to have a comprehensive insolvency law. Since then, we've had the Insolvency Law Committee, which Mr. Gaurav Banerjee also mentioned, which submitted its report in October 2018 and recommended that India adopt the UNCITRAL model law on cross-border insolvency with some modifications. And since then, however, the law hasn't yet been adopted. Right now, there is another committee that is looking into the rules and regulations to implement cross-border provisions into the Indian Insolvency Code, and also to look at group insolvency. In the meantime, of course, the market doesn't really wait for legislation to play catch up. There have been a number of cases under the Indian Insolvency Code which have been very complex and inevitably have also had cross-border elements. I think the most high profile of these in terms of the cross-border connection was Jet Airways, which Mr. Batra will talk more about. But even a lot of other cases have also had various cross-border elements, including Esser Steel, Amtech Auto, Videocon. There are many, many cases. And in the absence of any sort of legislation to look into to deal with cross-border insolvency, it has been up to the judiciary and the parties involved to develop case by case and specific protocols and other stopgap measures to deal with these issues that come up. But of course, these sort of measures are not a substitute for having a comprehensive insolvency legislation, which makes it all the more imperative that India does adopt an insolvency cross-border legislation sooner rather than later. So in today's panel, we hope to give you both an Indian and an international perspective of the UNCITRAL model law, and also going beyond in terms of whether India should or should not adopt the model law, but also to discuss some of the challenges and issues that might come up with the model law's implementation in the Indian context, based both on our experience with the IBC and also the international experience of other countries that have adopted the model law. With that, I would like to turn over to our first speaker of today, Ms. Kate Lennon from UNCITRAL, who will give us an overview of the model law and the benefits to states from adopting it. Over to you, Kate.
Thank you very much, and greetings to everyone from Vienna, Austria, which is the headquarters of the UNCITRAL Secretariat. Thanks very much to our audience for joining us today, and I think we'll dive right in since we don't have a lot of time to deal with a lot of very interesting issues today. So if we could go to the first slide, please. Many of you already know the answer to this, but let's just make sure we're all on the same page. What is cross-border insolvency? What are we talking about? Now, what we're talking about is a situation where you have one insolvent debtor who has assets in more than one state, so India and another country, for example, or the situation where some of the creditors of the debtor aren't from the state where the insolvency proceeding is taking place, so non-Indian debtors, or creditors rather, and then the situation where insolvency proceedings concerning the same debtor have commenced in more than one state. Now, obviously, domestic insolvency law is only effective within the confines of a specific jurisdiction, and you can't control the debtor's assets outside of that jurisdiction. So the model law is intended to respond to a perceived need that was established for a framework for cooperation and coordination that would both respect the sovereignty of national laws and procedural systems and allow the assets located in different countries to be treated comprehensively, transparently, and fairly. So that's why we have the model law. Next slide, please. Now, why are we concerned about cross-border insolvency? Some of our colleagues today, our fellow speakers, have touched on this already, but basically there are a number of difficulties associated with trying to deal with cross-border insolvency scenarios. You have a large number of cases constantly, increasingly more in future, no doubt, as we all emerge from the COVID-19 crisis. These contribute to delay, increased costs, very cumbersome procedures and formal requirements because of the cross-border element. You have a lack of authorization in countries to cooperate, conflicting court decisions on similar matters, and a great deal of commercial and legal uncertainty and unpredictability. Next slide, please. The negotiation of the model law had a number of very clear objectives, and these are actually set out in the preamble of the model law if you want to look at them in more detail. So the model law was trying to establish a means to cooperate, obviously, between courts and other authorities, to provide an answer in terms of legal certainty and predictability for trade and investment, to protect the interests of creditors and other interested persons, really importantly, to maximize and protect the value of a debtor's assets wherever those assets might be located, and to facilitate the rescue of financially troubled businesses, and as a result of that, protect investment and also preserve employment. Next slide, please. So some key aspects of the model law, just to discuss at the outset. So the first point is that the model law doesn't actually attempt to unify the substance of insolvency law from country to country. That's not the point. nor does it try to standardize procedural law. And in fact, the model law itself respects the differences in procedural law from country to country. Now, having said that, the model law is a unilateral law. And what that means is, because it's a model law, it has to be enacted by states in order to be effective. That makes sense. And that enactment actually signals that the state will accept applications for recognition of foreign insolvency proceedings from all other states, regardless of whether or not those states have implemented the model law. Now, this was very much a conscious decision on behalf of the drafters and of UNCITRAL in adopting the model law, that reciprocity would not be required. And it was felt that not requiring reciprocity and making it unilateral would greatly reduce, requiring reciprocity would actually greatly reduce the global functionality and effectiveness of the framework. So it was better to make it a unilateral system and thus maximize its potential for effectiveness. In addition, of course, as a model law, it's quite flexible. And if it were a convention, it would be quite cast in stone, all of the obligations in it. However, the model law is flexible, but in order to achieve the greatest level of harmonization and thus make it as effective and as predictable as possible, it's really best when countries can actually cleave as closely as possible to the text of the model law. And that's any model law, not just this model law. But if it's as close to the text as possible, you will have maximized harmonization and maximized effectiveness. And this is also reflected in the uniform interpretation article in the model law, Article 8, which asks courts to have regard to the international origin of the model law and the need to promote uniformity, and as well as to certain texts that UNCITRAL has prepared on its website. I'll get to that later. So next slide, please. Next slide, please. There we go. So we have, this has already been touched on as well. So as of today, we have 47 states, I think Myanmar was the latest one, that have implemented the model law globally, and 50 jurisdictions. So this is quite impressive. This has grown quite markedly in the last couple of years, and there are a number of countries that are in the process of considering implementation of the model law as well. So we consider this number to grow, and you can check the status on UNCITRAL's website anytime. Next slide, please. Interestingly, though, the increasing numbers of applications of the model law involve both countries that have enacted the model law, and those are the countries you see in blue on the screen, and countries that have not enacted the model law yet, and those are in black on the screen. So interestingly, you don't necessarily have to have enacted the model law in order to reap the benefits of it. Next slide, please. The model law applies in 4 specified situations, and this is in Article 1 of the model law. So so-called inbound requests. So you have requests from a foreign court for assistance from an enacting state. The so-called outbound requests, which are by the enacting state to a foreign state for assistance. Then you have the situation of concurrent proceedings in different states regarding the same debtor. And you also have the situation of creditors or other interested parties in a foreign state that have an interest in requesting commencement of or participation in an insolvency proceeding under the law of the enacting state. So there are a number of different scenarios in which the model law becomes relevant. And of course, the scope of the model law covers foreign proceedings relating to insolvency, where the purpose of the proceedings is reorganization or liquidation of the debtor, where the proceedings are collective in nature, and where the assets and affairs of the debtor are subject to court control or supervision. And that's under Article 2. Next slide, please. Now, the premise of the model law is that it establishes a simple and straightforward set of requirements that do a number of things. They minimize formality for recognition of foreign proceedings, as we mentioned. They facilitate predictable outcomes, as we noted. They reduce the scope for disputes or arguments about how matters are proceeding. And they recognize the need for speedy outcomes. And speed is really of the essence in many ways in insolvency, as we all know. So there are 4 key elements of the model law. The first is access. And what we're talking about here is access to local courts for representatives of foreign insolvency proceedings and creditors. The second pillar is recognition of certain orders that are issued by foreign courts. The third key element is relief granted to assist foreign proceedings. And the fourth element is cooperation among courts of states in which the debtor's assets are located in order to facilitate coordination of proceedings. Next slide, please. Now, in terms of access, what we're talking about is the situation where a foreign representative, in order to manage the assets of the debtor in a foreign country, needs to obtain access to them. And the model law does this by giving the foreign representative a right of direct access to the courts of the implementing state. The access isn't subject to any special conditions, but the foreign insolvency administrator can achieve is left largely to it. It's as a result of the local law, so subject to the local law and the discretion of the local court. So the provisions on access specify who has standing to initiate an action for recognition of a foreign proceeding or for assistance, and allows foreign representatives and creditors to commence or to participate in local proceedings. It also sets out the formalities that have to be satisfied and establishes certain evidentiary presumptions that can be made by the court in getting to that decision, and authorizes courts of the enacting state to seek assistance abroad for local proceedings, so the so-called outbound component. Next slide, please. In terms of recognition, so a foreign representative can apply for recognition of a foreign proceeding. And of course, this is a simplified procedure for recognition. What the model law does, it establishes very clear and straightforward conditions for recognition without unnecessary formality or procedure. And if those conditions are satisfied, the result is certain and predictable. In fact, if the conditions are met, the court should recognize the foreign proceedings either as main proceedings, or where the debtor has a center of main interests, or as non-main proceedings where the debtor has an establishment. Now, there is a small exception to this established in Article 6, which permits recognition to be refused in very limited situations where it would be manifestly contrary to the public policy of the recognizing state. This public policy exception is intended to be interpreted very restrictively and used only in exceptional circumstances. And in fact, this has been borne out by the case law. Next slide, please. Now, relief, the model law provides three main categories of relief. The first is quite important, and this is providing for discretionary interim relief, that is before recognition, in order to provide assets, to protect the assets of the debtor and the interests of creditors. Now, this period can be especially important because it's in the period between making of the application for recognition and when the decision on that application is granted. So there's a period of time in there during which the assets would need to be protected in order to preserve the overall value. The second area of relief provides for standardized and automatic stay as an effect of recognition of the foreign main proceedings. And the third area is discretionary relief that is provided for foreign main and non-main proceedings. Now, with respect to both interim and discretionary relief, the court can impose conditions and can modify or terminate the relief. And again, this is to protect the interests of creditors and other interested parties as the context develops. Next slide, please. So on cooperation and coordination. The model law provides express legislative authority for judicial cooperation in order to facilitate communication between courts and case management coordination. So it authorizes cooperation to the maximum extent possible, including direct communication between courts, so that is courts in a cross-border sense, between courts and foreign representatives, and between foreign representatives themselves. The model law also facilitates coordination of concurrent proceedings, does not, in doing so, prevent commencement of local proceedings, and commencement of local proceedings does not terminate or prevent recognition of foreign proceedings or foreign proceedings that have already been recognized. Next slide, please. So that's a very, very quick overview, and I know we're going to get into more detail and discussion afterwards, so I hope you will you will be happy with that brief discussion. But basically, the large majority of cases that have occurred under legislation implementing the model law, approximately 90% of the applications for recognition are routine and are routinely granted very clearly on the conditions set out in the model law. Now, UNCITRAL has a number of additional texts that help for interpretation and additional tools that are available on the website. You see some of them listed there. And on the next slide, we have additional insolvency texts that were referred to a few minutes ago as well. UNCITRAL has recently adopted the model law both on enterprise group insolvency and on recognition and enforcement of insolvency-related judgments. And of course, we do have our 4-part legislative guide on insolvency law as well. So with that, I will conclude these opening remarks and look forward to getting a little more deeply into the issues with some of the other panelists. Thank you.
Thank you very much, Kate. That was a really helpful and very succinct introduction to the model law. And I think there were quite a few interesting points here. I especially remember that you made the point on reciprocity and how the model law does not require reciprocity. I think that is an interesting point that's going to come up in today's discussion as India is considering enacting the model law. So with that, I would like to now invite our next speaker, Dr. Vishwanathan, to provide a brief historical perspective on India's efforts to adopt the model law so far, including the report of the Insolvency Law Committee that recommended adopting the UNCITRAL model law. And also, sir, if you can discuss any specific concerns or challenges that you think India might see with adopting the model law. I think one such issue that has got a lot of discussion is COMI. So any of these issues, if you could discuss now. I'll also get your slides and share the screen with you in a minute, but over to you, sir.
Thank you, Aparna. Thank you, Kate, for an excellent bird's eye view of your model law, because there is not much of a, literature on the subject. Many lawyers are not aware. Let me start with, am I audible? Can you hear me?
Yes.
Okay.
Yes, you are audible.
Let me start with an apology, because when I gave the report, Bankruptcy Law Reforms Committee report, I was aware we did not provide for cross-border insolvency. No, that was the bill, the code, the Insolvency and Bankruptcy Code was a huge challenge which was entrusted to me by the Finance Minister Arun Jaitley at that point of time, because 2 attempts were made to consolidate the law regarding insolvency and both failed. As Suman Batra will know, we were battling for a long time to have a single law which we failed. So when we started working, it took some time. And ultimately, what happened, Minister had committed that he will introduce a bill on 2015 on some particular date. So we have to rush with the drafting of the bill, and we completed it with a breakneck speed. Now, the reason why I did not contemplate providing cross-border provisions, we did lack the legal systems. We didn't have a single bankruptcy tribunals, dedicated tribunals. We didn't have a consolidated law on the subject. Then we lacked this resolution professionals and also information utilities. So we simply gave up. But when the bill went before the committee, I was the first person to testify before the committee on the provisions of the bill. I was confronted with this question. They asked me, members, all the parliament, cutting across political spectrum, they asked me, why are you not providing for cross-border provisions? Are you not aware this is going to create a lot of problem? I said, I'm aware of that, but then we can be followed up later. But then the committee gave us an interim solution. They inserted 2 sections, 234 and 235. I said, this is a stopgap measure, but they said sooner or later we have to provide for cross-border provisions. You do that. Now, this bilateral treaty, as you are all aware, is not the best way of dealing with cooperation between jurisdictions. We have difficulties even within our own country where different courts have problems. We need a dynamic legal framework and rules needed to deal with cross-border issues. A treaty cannot be a substitute. We need a multilateral instrument where there is a cooperation between different states. So the section 234 and 235 of the code offers many challenges. One, we have to enter into an agreement with each country. Then it will be difficult to know at any given point of time whether a case relates to a country where we have a treaty or not. And secondly, the request has to go after the application is made to an adjudicating authority, and the adjudicating authority is satisfied, an application should be sent to a different court. And this is also always been a big problem. And the debtors' assets will be located in many different jurisdictions. It will be difficult for having treaties or agreements with all the countries. So it is not a very happy experience. Moreover, India's experience in matters of reciprocal agreements has not been very happy or encouraging, because in most of the cases, recognition of foreign judgments and proceedings, we have section 13 and 44A of the Code of Civil Procedure, which deals with execution of decrees passed by courts in reciprocating territories. And a reciprocating territory means any country or territory outside India, which the government of India may by notification in the official gazette declared to be a reciprocating territory. And if a certified copy of the decree of any reciprocating territory is filed in a district court, then the same shall be executed as though it had been passed by the district court in India. But then, it doesn't work that way in India. At every point of time there is a delay, and then it creates a problem. So the second issue arises when we have a ready-made model law where many countries have seen, why India has not acceded to that. Now, first of all, the need for an insolvency and bankruptcy law itself was long felt, but then we were very ambitious in trying to combine both individual insolvency and corporate insolvency. And then having done that process, I didn't want to stretch my luck into pushing to something, because when you have an agreement or some concession which you're giving, the parliament, the question always arises, what is in it for us? What do we gain? They think it's a bargaining chip. It becomes difficult. We saw that in reciprocity. When in the insolvency committee, when we were debating, there's another background to that. What happened after the bill was enacted? Suman Batra and both of us collaborated, and we worked on this, implementing the model law on UNCITRAL model on cross-border insolvency. And we prepared a draft bill. And in somewhere around 2016 July, I went and met Finance Minister Arun Jaitley in Parliament. He was sitting in Parliament, and I told him, sir, my job is incomplete. Without this, we have a problem. Now this model law is readily available. Let us implement it. He was nice. He was very dynamic. He said, oh, what do you do? I said, everything is complete. I have the bill with me. I have produced Batra, and both of us did it, implementing the model law. It's subject to certain modifications. Aparna is aware of that. She has been a party to that draft. And we prepared everything from statement of objects and reason, notes and clauses. The only thing that was missing is in Hindi version, which I couldn't do that. I gave this USB drive to Finance Minister, and it was handed over to the Ministry. But then, it went on. They said it is not very urgent. What's the tearing hurry? Because the bankruptcy board has to be constituted, let us wait. But then it went on, lingering, and then a committee was constituted. And in this insolvency committee also, what happened? I suggested a standalone legislation for the simple reason. It gives visibility, better visibility. When you enact a legislation, we did that for Arbitration Act in 1996. When we give implement by the resolution of the General Assembly, the preamble will state that, and it gives a clear mandate to the Parliament and the central government to enact legislation to give effect to an international multilateral treaty. So, but then what happened? Somehow the thinking arose in the ministry, it should not be a standalone legislation, bring it inside the code itself. Because I foresaw a situation where this model law on cross-border will be a prelude to future courses of cooperation in other cases as well, not only merely to insolvency or bankruptcy, to other types of cooperation which is going to happen. No, litigation is flowing across the borders, and courts of countries are having to interact with each other. So, but then that is one issue. But then the ministry had its way, and the recommendation goes as an inclusion of it in a chapter inside the IBC. Secondly, some of the thinking was we should insist on reciprocity. We try to argue it is not really a happy situation. It's not, doesn't give us any value, but somehow they think it's a kind of a bargain. I don't know. This is some mental reservation is here among certain sections of the stakeholders. I don't want to name them. That reciprocity is required because you should insist. Otherwise, you'll be giving away something which, in return, we don't get. But that's not correct, as we said, because outbound requests will be difficult to fulfill. Inbound requests may come. I will not touch upon that. So then what happened? Multilateral treaty model law is essential and we should implement it. But the thinking government also said at some point of time we would bring in an ordinance to implement it, but it didn't happen. And now Aparna is in a part of a committee. They are doing some rules. I don't know. I'm not aware of what. Maybe she'll throw more light on that. It's only a question of time because we are having more and more cases, cross-border cases, and we are in a situation where sooner or later we will have to adopt something. And this adoption, this bilateral treaty is not a very happy thing. No, the model implementation of model law, I don't see many great difficulties except on two counts. One is cooperation between the bankruptcy tribunals between India and the foreign countries. Actually, what happened? I when I started drafting, I was given the choice. I had to think about which body, which authority will administer the bankruptcy law. Normally, in India, the courts, high courts are all supreme, and high courts and Supreme Court. The courts are very reluctant to part with the jurisdiction because the individual insolvency was in the district courts, then the other part of company law was in the high courts, etc. They were very reluctant. So the thinking was, why are you investing so much money in tribunals? You can give that money to the high courts, we will handle. That is, many of the high court judges whom we reacted were of the view that we should not have this national company law tribunal, etc. You give it to the high courts, we will do that. You give the money. But if we hand it over to the High Court, then we will not be able to drive this code as the way we are doing it right now. The insolvency in bankruptcy code is a code. I maybe it is a historic code in this law reform because it is continuously being monitored. The only other law which has been continuously monitored in the Indian legal context is the Income Tax Act and the Customs Act, where revenue implications are involved, where the government knows if you touch any item, what will be the revenue inflow, what will be the effect, who will be affected. No other law has matched up to this standard, but insolvency and bankruptcy code has come to that standard because we're continuously monitoring and continuously amending the law. And we have an excellent understanding with the courts. Courts are very sympathetic in advancing the spirit of the court. So, so the bankruptcy, the national, then the judicial. I was talking about judicial cooperation. Now, when you talk about judges of one country talking to another country, Judge Gropper is here. I know, Justice Gropper. I had a great opportunity of attending one of your American bankruptcy judges dinner in Alexandria in 2016. It was a great moment. I don't know whether you were there at that point of time. All of them were very keen to come to India and see and they learn. They not only to teach us, they were interested in learning. The challenges in India are very different. We have very different type of models. So they were very curious to know, and they said their experience we will share, and we want to share your experience. So the judicial cooperation will require online hearings, joint hearings, and I think that will require some kind of a capacity building for our judges, bankruptcy judges, who can interact with the foreign judges and understand, because these are all going to happen. Now we have online, courts are going online, things are all happening online. So these are some of the challenges. Another sticking point which I foresee is combing, where people or nationalists will believe, oh, the center of main interest, we should take care. So when we drafted the legislation, we left it very open. Aparna knows that, so that we can, by rules, jurisprudence can evolve depending upon a case-by-case basis, and it is easy to manage. The most important thing which foresee is a judicial cooperation between the bankruptcy judges of India and other countries. I am very sure this can be overcome. This can be overcome. It's not a question of great difficulty in handling that. The modern law, as Kate has said, does not change or intrude into the substantive law of India. It's only facilitating, it gives you access, recognition, and cooperation. And I think there cannot be any major hurdle in India adopting this model law. I think in the mental block on reciprocity can be addressed, and I'm very sure in the times to come we will see this UNCITRAL model being part of the statute, because as a draftsman, I have drafted many legislations for the government for more than 3 decades, and it will be a flower in my feather in my cap if I can see that happen in a very short time. Thank you. I'm looking forward to hear from Suman Batra, who I'm not met for quite some time. So we collaborated and we're still collaborating. Thank you. Thank you.
Thank you very much, sir, for that very helpful perspective on the IBC as well as the model law. And also, we really like the optimism that it's likely that the model law will soon see it be part of the Indian legislative framework. I'd like to now I'd like to ask Mr. Sumant Batra to give us a practitioner's perspective on the model law. Specifically, I think based on your experience, Sumant, I know that you've dealt in a lot of cases which have had cross-border elements, and it would be helpful to get your perspective on how you think the model law, if India had adopted the model law, how it would have helped in these cases in terms of timing, efficiency, cooperation, etc. And also, I think we would really like to hear about your experience in the Jet Airways case and the protocol that was developed between the Netherlands representative and the insolvency representative in India. So over to you, Sumant.
Thank you so much, Aparna. Thank you, UNCITRAL, for having me on the panel today. And it's so good to be with such esteemed speakers, all of whom I'm very familiar with. And it's such a pleasure to be seeing you again. Just flashback to 1998, that was the first time I heard of the UNCITRAL model law, when the UNCITRAL Secretary General visited India together with Neil Cooper, the then president of Insolvency International. We had a conference and we had a great dialogue about what was happening worldwide. And that was the first time, at least I and many of us in India heard about the cross-border insolvency law. And I do know that snowballed into a formal discussion at various levels as to see how we could actually even consider doing that. But in the absence of even a domestic law, which could be anywhere close to the global standards, it was unthinkable that we would be able to have any conversation around a cross-border insolvency law. But we did when in 2005, around that, maybe 2004, I was a part of the committee that the government of India had set up. It was called a J.J. Irani committee. At that point of time, J.J. Irani committee recommended, as a part of the insolvency reforms, domestic insolvency law reforms, that the government of India should also consider adopting the UNCITRAL model law. While the bill that was drafted ultimately, with my assistance, somehow the UNCITRAL model law path slipped through the cracks as probably a policy decision that the government took at that point in time, which I was not privy to. I've never really heard and known why, but it just sort of slipped and lost visibility. And eventually, when the bill was tabled in the parliament and was passed in 2013, we didn't really have it as a part of the insolvency law as it was then passed by the parliament. But of course, we all know that in 2014, Bankruptcy Law Reforms Committee was set up, and eventually even that 2013 law was not implemented. Now, so it's been quite frustrating for having attempted this for almost like 15 years now, proactively. I know how many numbers of trips Jenny, Kate's predecessor, has made to India. Judge Wisset, who was one of the ambassadors of this law. We've tried everything within our means to make it happen at the policy level, and it's always been positive. And I was obviously, it was a delight to work with Mr. Vishwanathan, because he was very convinced that this is what is required, and I'm delighted that we were able to put together a draft, and invariably that's the draft that has been approved by the Insolvency Law Committee. With reciprocity is something which, as you heard from Mr. Vishwanathan, is something which we have not been able to convince them on. Although I still see some hope, because there is a possibility that the matter may be referred to the Select Committee. We may still have opportunities to make representations there, and we might just still be able to persuade the government to reconsider, because we all know that the South Africa experience on reciprocity has been very bad, and it's been absolutely a redundant law. And I've heard and seen some of the top leadership of insolvency coming out of South Africa being very frustrated about it, that having even enacted the law, but with reciprocity, you've just sort of made it as something which is just in the bookshelf as a law. We haven't really made any effective use of that in South Africa, as I understand. Now, so I do share Mr. Vishwanathan's optimism in that sense, because I think the government realizes that without the UNCITRAL model law on cross-border being as a part of the statute book, they wouldn't really be able to sort of go out and project themselves as one of the top 50 economies on the ease of doing business ranking, as what the aspiration of this government is. And they have actually climbed up quite fast, and this would give them a big jump as well. So there's another motivation, which an incentive which the government has to make it happen. When the law was passed in 2016, December 1st, it was made operational. The first list of cases, a dozen of them, comprising 25% of the total non-performing assets on the books of the Indian banks, were filed somewhere in June, between June and July. And out of those, I was advising on 6 out of those 12 different stakeholders. And 3 of those were purely cross-border. Amtech is something which Aparna mentioned, and I would take that as something which had assets in Japan, Thailand, UK, 6 European countries, America. And imagine you were talking of an automobile parts manufacturer with manufacturing facilities located in almost about 8 to 10 jurisdictions. And some of these were in countries where these assets were going through a restructuring themselves or had receivers appointed. And also, I forgot to mention Singapore. And we were so frustrated because most of the value lay in these assets, which were part of various subsidiaries or group companies. But we were so helpless, we just couldn't really reach out to those. And because the receivers and the liquidators and the administrator, or even otherwise the management, where there was no such distress situation, they were not just willing to cooperate because they were under their own confidentiality agreements. They were accountable to their own courts or contracts. And we were able to use our good offices through my relationship with Insol International, to be able to sort of reach out and use my personal influence and rapport with them to be able to at least get some sense of what it is, so that potential investors would have some visibility of what those assets were all about. We were not able to include them in the virtual database. We were not able to include them as a part of the information memorandum, and therefore any information with regard to the assets and their value was completely hypothetical. Imagine the immense loss to the Indian lenders. And I went to the secretary in the Ministry of Corporate Affairs, and I gave him a dossier, a 2-page dossier on this. I said, this is a loss to the Indian lenders. This makes out a perfect case to accelerate the enactment of the UNCITRAL model law. But I can understand their reluctance because they wanted the Indian insolvency law to stand on its feet, stabilize, and only then, and after they had the confidence that the Indian judges and the practitioners were prepared or sophisticated enough to be able to deal with cross-border insolvencies, particularly those coming from very advanced economies where you already have the cross-border insolvency law in place for many, many years. I respect their concerns, but I do feel that the Indian market is capable of really catching up very, very fast, as we have demonstrated when it comes to Indian insolvency, domestic insolvency law. We have done exceptionally well for ourselves, and I'm sure that we are capable of doing the same for the UNCITRAL model law on cross-border insolvency. So the Amtech is something which the frustration started with, and then the other was the Videocon, where we're dealing with oil fields, where we're dealing with a huge number of companies, layers of companies and values, where the governments of the sovereign governments of the other countries were involved, petroleum corporations of the countries were involved, and even the Indian government corporations were involved. But again, we felt so handicapped in the absence of a cross-border insolvency law. We had to deal with the contract law, we had to deal with the corporate law, but we didn't really have access to the insolvency law. But that was all something which the government was getting as a feedback, and it was weighing on their mind that this actually is something that they really need to do something about. And Jet Airways, I think, is something which really happened as I would say the final point, and nobody had really expected that Jet Airways would turn out the way it turned out. I'm happy to share some details, although not diving into too much in detail. But it also happened that in India the lenders had decided to take over the management from the erstwhile promoters of Jet Airways, and most of the airlines it was inoperational. The aircraft was grounded. Nothing really was happening. But the lenders decided that they wanted to take over the management. They had lost confidence in the erstwhile management, the promoters. In the meantime, in Netherlands, where the Jet Airways European hub was at the Schiphol airport, Jet Airways had defaulted to a number of its lenders, small in size, not very significant, but not as irrelevant as well. And they had some staff there. They had an aircraft which was lying at the Schiphol airport. A winding up petition was filed, and Netherlands District Court, Bankruptcy Court, ordered winding up. It was an ex parte order. Nobody appeared despite notice from Jet Airways, and an administrator was appointed. An administrator reached out to me to see what can be done, and I then spoke to the people in the government and everything, and I said, this is something which you can't afford. That you do have the entire value is located here. If you have to restructure, then you can't afford a liquidation order being passed elsewhere. So we need to do something about it. But for reasons best known to the lenders, they decided not to intervene or even appeal the order in the Netherlands. In the meantime, some trade creditors filed insolvency petition in India against Jet Airways, and that's when the main lender, which is State Bank of India, also decided to file a petition. And when that petition was filed, we filed an intervention on behalf of the administrator in Netherlands to tell the judge in India that there is already an order passed, and in the face of that order, would you want to consider passing some suitable orders for cooperation for some kind of dialogue between the administrator and the insolvency profession? They're going to appoint here. But unfortunately, the judge did not allow us to file an intervention application. He was of the view that there's no cross-border law. He was of the view that since the registered office of Jet Airways is in India, Netherlands court does not have the jurisdiction, and therefore he rejected our request for intervention. And not only that, he unfortunately went ahead and even directed the Indian insolvency professional to just ignore and disregard the proceedings in Netherlands and not even get in touch with the administrator or have any open cooperation or dialogue with the administrator. That was completely unwanted, in my opinion. We filed an appeal against that order before the appellate court here. And fortunately, the appellate court understood the implications. And so thankfully for me, the appellate court judge, who was the president of the appellate court, had been to an Insolvency International conference in Singapore a few weeks back and had attended the judicial colloquium, had understood what UNCITRAL model law is and how that order was by the lower court was perverse. And he therefore, on my request, said that he stayed the order as far as the cooperation between the prohibiting cooperation is concerned, or even recognizing that order is concerned. And he directed us, the administrator, my client, and the insolvency professional appointed in India to sit together and work out a mechanism for cooperation and see how they can reach an amicable thing. When in less than 30 days, the lawyers of the Indian lenders, the law firms advising some of the other stakeholders sat together and came out with a protocol. Now, that protocol was nothing less than just a mirror image of the UNCITRAL model law. We just picked up the UNCITRAL model law. We created a hypothetical situation. Were the UNCITRAL model law in place, how and what would you do? Where the main proceedings would be, where the COMI would be. How would you do, how do you behave and act and determine the rights and interests and duties of the parties and their priorities and recognize the independence of each court and everything. We virtually had operated in the shadow of the UNCITRAL model law and came out with something which all the parties fairly agreed would be the best solution. which is to maintain the independence of neutrality and sovereignty of the courts in Netherlands as well as in India, giving superiority to the domestic law, clearly agreeing that nothing would be done which would be the contrary to the public policy of both the courts, recognizing Indian proceedings as the main proceedings, and and in fact we even went to the extent of even saying that the costs of the Netherlands would be paid out of the costs of the corpus that is created in India, and any asset that is sold out of Netherlands, those would be just parked as a sale consideration, will not be utilized. It will be utilized as a part of the overall distribution that will be done under the Indian law. Not only that, even the fees, the costs of the administrator was agreed to be paid out of this common corpus. And in fact, to the extent, and this is where in fact we took the leap of faith, I would say, that the administrator in Netherlands was allowed to attend the meetings of the Committee of Creditors in India of Jet Airways. Although of course not allowed to vote, which we never even asked for, but we were allowed to participate physically, including with their legal advisor, and have an open dialogue on that. And it has worked exceptionally well. And when we went to the court, the Indian lenders had some apprehension about allowing attendance to the COC meetings initially, but they stepped back after some resistance. And eventually what we had was in 2 hearings, or at best maybe 3 hearings, a protocol being agreed. Now, this in itself is something which demonstrates that Indian stakeholders are capable and sophisticated enough and mature enough to be able to play on the playground of the cross-border insolvency. It is not that we are not prepared. Indian professionals are very high quality. Indian lenders are very well exposed. Indian judges are very capable. And with some capacity building and learnings of the international experience, we will be able to actually come up to speed very, very fast. A couple of other observations that I want to make about Jet Airways is that not just did we agree on a protocol, we were able to act on it also very smoothly. So much so that it was agreed that we would sell the aircraft that is lying in Schiphol Airport. I'm only sharing all that what is in public domain, and nothing, of course, which I'm bound by confidentiality not to disclose. We also agreed to have joint meetings with Schiphol Airport authorities and with the lenders. It's a different matter now. Jet Airways has winding up petitions being now in London and in Paris as well. I guess, if not in Paris, certainly in one more jurisdiction. I am not very aware of as to how the cooperation is extending to those proceedings, but so far it has just been excellent, and I think Jet Airways works out as a perfect model. But having said that, Jet Airways, even as a protocol or even as a precedent, doesn't really come out as a substitute of the UNCITRAL model law. We do need a model law because that as a precedent, it was successful in one case and may not really work in another case. So we do need a legislation. We do need a structure. We do need a framework. We do need all the stakeholders having complete certainty about what is it that is available in order to create a level playing field on the UNCITRAL playground, on the insolvency playground. The last observation that I have is that I do believe that this is something which we need, and there's no two opinion and two views about it. Although my hunch is that given the COVID situation and given that there has been a complete destabilization of the Indian insolvency industry as a result of the lockdown, in particular when we are at a very nascent stage, a very delicate stage. We had just about taken off. I mean, I would say the wheels had just left the ground as far as the Indian insolvency law is concerned, and suddenly you have the wind taken out from under the wings of the aircraft called Indian insolvency law. We've been forced to ground, and only yesterday the ordinance has made it clear that we can still go ahead, which would obviously take some more time for us to allow the IBC to again move forward with the same level of energy, dynamism as it was doing before 20th of March. And I have a feeling that the government may just go a bit slow on the UNCITRAL model law enactment before they feel that the IBC is back on its feet once again, which means that another 3 to 6 months. I won't be frustrated about it, because I think as long as we are making progress, and it's very good progress, we should really make it happen. And we need time in the meantime to have judges capacity building. We need to do other kind of groundwork. So thank you so much for this, Apana. I apologize if I've taken longer than what my time slot was. I was not looking at the watch, but
Not
I was
at all.
looking for.
No, not at all, Suman. Thank you so much. That was really helpful, and I think a very, very strong case for India to adopt the model law. I mean, we do understand, given the circumstances now, it may take a little longer than expected, but I think the Jet Airways case was really a wonderful example, which, as you mentioned, Sumant, was basically functioning in the shadow of the model law. So it worked in that situation. I think it's a great example to hold up to any skeptics about any skeptics who may remain on adoption of the model law, that this is something that the Indian market and the industry can handle. I'll now turn over to Justice Gropper, to Judge Gropper, to give us some of your experiences on the United States adoption of the cross-border model law and any challenges or issues that have come up in the cases to do with the cross-border model law. So without further ado, I'll turn it over to you, Judge.
Thank you for this opportunity. As I can see from the technology we're using today, things have changed a bit since I spent a year in India in 1965, where we were very lucky in the city where I was, Kanpur, to have a telephone. There was perhaps 1 or 2 telephones in the city. In any event, the US adopted the model law in large part in 2005. We had a prior statute called Section 304, which was much shorter, but provided for recognition and enforcement of foreign insolvency laws and decrees, subject to certain conditions. But these conditions and the procedures were set out much more clearly in the model law and provides a statutory basis for a court to allow cooperation, to provide for recognition, and provide for enforcement. I'm sure that the judge in initial instance in the Jet Airways case had no statutory basis to look to. And although we in the United States, and I believe India, are recipients of the common law, judges will just go so far in developing procedures. And I think the model law facilitates an understanding of the importance of cooperation, of recognition, and of enforcement. As you know, in the US version of the model law, as in the original, there's no requirement of reciprocity, and there was none in Section 304. We found as a nation that there's no relationship between the question of recognition of a foreign nation's insolvency law or practice and whether or not that nation has itself adopted the model law. And if so, what constitutes a reciprocal recognition? Because although many nations have adopted the model law, there are some amendments. We rejected reciprocity early on, and we still reject it firmly. I believe that the model law, which is Chapter 15 of the Bankruptcy Code, has been an unqualified success. As of the end of March this year, there had been 1,400 Chapter 15 cases filed. I don't have the exact number where recognition and relief have been granted, but I believe that the information we have is that the overwhelming majority have received the recognition that they sought, and and that relief has been granted very often without any opposition. We mentioned Jet Airways. I don't believe Jet Airways flew to the United States, but those foreign airlines that have gone into proceedings abroad, such as Japan Airlines, the Swiss Air case, which I had, they all brought Chapter 15 petitions in the United States to protect their planes, which in the reorganization case proposed to continue to fly on the US flights. And if they hadn't gotten relief, presumably they might have feared to fly into the United States. A good part of their business would have been ruined, and their efforts to reorganize perhaps would have been jeopardized. Chapter 15 permitted the US courts very quickly to enter orders that protected the planes, and indeed did so even before recognition was granted. I don't believe there was any question there certainly was no question in the Swiss Air case I had as to where their comey was, as to whether or not the proceeding should be recognized. And it was important that the court could grant a preliminary injunction protecting the planes even before the order for recognition came on. And in the US, it comes on quite quickly, but generally takes perhaps 20 or 30 days to give notice to US creditors and to provide them with due process. And in the meantime, the planes were protected because the airline could show that it would suffer what we call in the US irreparable injury if there were not an interim order entered to protect the debtor's property. So I believe the statute has been successful in achieving the goals of the statute set out in Article 1 that Kate mentioned. A well-known example of judicial cooperation in the United States involved the cases of a huge telecommunications company called Nortel. The Canadian parent went into insolvency proceedings in Canada. The US subsidiary, which was the largest, went into proceedings in the United States, and the European and English companies went into proceedings in London. There was a successful sale of the assets. It turned out for more than $7 billion. That used to be a lot of money. It still is, in my view. And the $7 billion, however, hadn't been allocated among the different companies. Finally, after spending hundreds of millions of dollars, even over $1 billion in expenses, there was a joint trial between judges in Delaware in the United States and in Toronto. Fortunately, they speak the same language we're now speaking. They could have a joint trial by television. They issued separate opinions based upon their own statutes, but fortunately they were similar, and the litigation finally was brought to a conclusion. Let me now just touch on a few of the provisions of the US version of the model law, Chapter 15, that have been relevant. One is that Section 1502, subsection 3, which is Article 2, subsection 3 of the model law, permits the controlling or supervising authority to include an administrative agency, not merely a court. In a case called Ashapura Minicam Limited, the foreign representative of a debtor in India sought recognition under Chapter 15 of a petition for a proceeding that was then pending before the Board for Industrial and Financial Reconstruction under the Sikh Industrial Companies Act of 1985. U.S. creditors who were suing this entity in the U.S. objected. They wanted to continue their litigation and try to seize U.S. assets. And they argued that this particular statute was going to be amended and repealed, which I gather it was. And they also argued that an administrative agency was not competent to act as the supervising authority under Chapter 15 in the model law. This was rejected by the court, which recognized the Indian proceeding. I think that's the only reported case where the U.S. courts have recognized an Indian proceeding. I might note that if reciprocity had been required, recognition would have been denied and no relief could have been afforded or would have been afforded to the Indian debtor. The model law, as you know, provides that a foreign proceeding can be recognized as a foreign main proceeding if it comes from the COMI, the Center of Main Interests. When I was younger in the United States, we spent a lot of time looking for commies. Unfortunately, we did, under the table and elsewhere. Today, under the model law, we look for COMI. Well, fortunately, it's not quite as fruitless as our old search looking for commies. There are a lot of disputes over COMI, but very few cases in which the issue has been determined adversely to the foreign nation. Particularly the cases in the US come from the tax havens in the Caribbean. And I don't think they'd be terribly relevant in India. The model law, as you know, provides, in Chapter 15 provides, that the court can deny relief if it would be manifestly contrary to public policy. The courts have construed this statute numerous times and have, I believe, properly given it a very narrow reading, so that there would only be rejection for an issue that was a major issue of public policy. Even we have a constitutional right to trial by jury. And in one case, it was argued that if you make US creditors file their claims in Canada, they won't have a trial by jury for their personal injury claims, which, as you know, is a big industry in United States law. The court rejected that and said, even though it's a constitutional right, you still don't have a manifest violation of public policy if you have procedures in Canada that are fundamentally fair and in accordance with due process. There's been little dispute over our construction of Article 21, which provides for relief under the model law. And I would only, in conclusion, mention Article 21 and 22, which provides that in granting relief, the court must be satisfied that creditors and other interested parties are adequately protected. We say sufficiently protected because we already use the term adequately protected in our bankruptcy law, but it means the same thing. So if there is concern that there will not be enough latitude under the model law to provide protection to domestic creditors, and indeed to all creditors worldwide of a particular debtor. That's built into the model law, and we've construed that provision in one case to restrict the ability of a German receiver, a German trustee, to reject U.S. patents. In any case, to conclude, I believe that the model law has been a great success in the United States, and that it does create a framework for international cooperation and communication in the insolvency sphere in our globally integrated world. Thank you.
Thank you so much, Judge Gropper. I think this was really helpful to hear about the specific examples you'd given of how cases have been decided under the model law in the US. And so now I'll turn it over to Advaita. I think we have a couple of minutes for questions.
Yes.
Yeah.
All right. Thank you, Parna. Thank you to our distinguished panel for having this elaborate and informative discussion and sharing their practical experience today on today's theme. The major takeaway definitely from today's discussion is the imminent need for India to adopt model law, particularly in light of the various cases discussed today by Mr. Batra, Jet Airways, Videocon, and so on. Especially keeping in mind the issues with respect to areas of insolvency and whether to group insolvency and whether to adopt principle of reciprocity or not. Though it's clearly visible that the approach of Government of India, it has been proactive and in continuously upgrading the code and bringing at par with the other mature jurisdictions. Adopting model law would not only bring in more certainty to the system, but also generate trust in the foreign investors and creditors. On that note, and without further ado, I would start with the questions and answers. I see many questions on in the area of alternate dispute resolution. So who better than Judge Allen to just start with the question on alternate dispute resolution? So my first question is to you. What role do you see for alternate dispute resolution mechanisms, particularly mediation as a tool for resolving cross-border insolvency disputes? In particular, do you believe that experienced mediator would contribute to effective resolutions in non-contentious situations that arise in cross-border insolvency? So
yes, I do think a mediator can be of assistance, and I think arbitration as well. Where you have a case like Nortel with major subsidiaries throughout the world, there was in that case a fund, billions of dollars to divide up, but there are always disputes among subsidiaries when there are multiple insolvencies. And I think particularly arbitration could be of great assistance in resolving these cross-border disputes. In the Lehman case, there were billions of dollars of disputes between claims filed by the English administrator. There were administrators, I think, in 100 jurisdictions throughout the world. And the most difficult claims to resolve were these intercompany claims. I think arbitration could be of great assistance there. The new law, the draft new law, well, no, it's not a draft, the proposed new law on group insolvencies specifically mentions mediation and arbitration as a mechanism for cooperation.
right, sir. Thank you. My another question is stemming from the previous question and is for Mr. Batra. Sir, your views on the same question in context of India. Will it be wise for India to incorporate ADRs in the domestic as well as cross-border insolvency regime?
Well, I think yes. Yes. Well, thank you. Certainly, yes. And I think we need to be futuristic in our thinking. We don't have to be always reactionary and wait for some of the other countries to sort of come up with more experience and more examples. And incidentally, we had a call this morning to discuss. We have a UK government assistance in India. It's a 5-year project, and we were discussing the agenda for a meeting with the ministry and the government, the IBBI, on Wednesday, and we agreed that this is something which we should also have on the agenda to discuss. That the government should start at least sow the seed in their minds that this is something which they also need to start thinking about. It won't happen tomorrow. We need to start thinking about. So definitely yes. I mean, and Adwaita, if you don't mind, can I just make 2 more comments?
Sure,
one from Judge Cropper and. In fact, 2 of them coming to that Cropper's comment. And one is that in the Indian context, unfortunately, one of the pitfalls that I see is that the granting of the preventive relief or the interim relief, as we call in India, because under the Indian insolvency law, the judges do not have the power. The law does not have the power to grant interim relief. Only after an insolvency petition is admitted that they can grant you any kind of protection. Which is obviously a matter of concern, because in cases of cross-border recognition, required time, the even but while application is being considered, some protection might be needed. And that is another area of concern that I see, because that is a challenge. It's a conflict with the Indian policy issue, because Indian insolvency law is not to have interim relief powers for the judges. So that's one matter of concern that we have. The second is, which is about judicial cooperation. There's nothing mentioned about that, of course. But I just wanted to mention, for the benefit of the panel as well as the viewers, that the Insolvency Law Committee has recommended that the government of India should consider India being a member of the DIN network. And I don't know what started by and one otherwise. India was invited as an observer to that, which was the president of the Indian Insolvency Court. Justice Kannan Ramesh of the Supreme Court of Singapore, who is leading that initiative, visited India, met the Indian government authorities, and made out a case for that. The GIN network probably has about 7 or 8, maybe 12 countries already as a member, from UK, New Zealand. So, so with that, go hand in hand together. They connect, and we is a recommendation group which I was a member. We have made a recommendation. Fortunately, we have 2 judgments of the insolvency courts on group insolvency permitting procedural consolidation, which we have used very efficiently in many cases. I had the honor of assisting the court in the first one, and we still don't have enough clarity on this, but we have made some progress. But that's another area on which we need to work hard on.
Right, sir. Thank you. I see many questions on reciprocity, but I believe it's already been covered during the speeches of Dr. TKV and Judge Cropper. So I would move on to another question, which is with respect to group enterprise. Kate, I would like to ask this question to you. So last year, UNCITRAL adopted the model law on enterprise group insolvency. What are the challenges for states to adopt it, given the most states do not have group insolvency laws for their domestic insolvency regime? Until they do so, is implementation of cross-border law limited?
Thanks very much for that question. To some extent, I think Sumat has sort of begun to address that in his comments that he just made. But first, at the outset, the model law on enterprise group insolvency is actually specifically designed to work with the existing model law on cross-border insolvency, and it's meant to be a complementary model law and not an alternative. So the terms, the mechanisms, etc., although there are some slight differences, will work together so that the entire package of model laws will work together in insolvency. So to that extent, there's no there's no internal conflict, there's no specific concern. Of course, some of the concepts in the model law and enterprise group insolvency need to be understood by the implementing state. So if there's no means in the domestic legislation to sort of understand or deal with some of those concepts, there may need to be some legislation that needs to be passed, etc. But there shouldn't be any sort of implicit barrier. But of course, there has to be a level of sophistication and understanding that goes with it, and a procedural means of dealing with these very complex enterprise group insolvencies. So we've heard in Sumant's remarks that in some ways there can be sort of procedural means established on sort of a contractual basis to deal with these issues. But of course, the best case scenario is to have an underlying legislative scheme that will support it. So there's nothing to say that it can't be done. Of course, it's much easier if you have the underlying legislative scheme domestically as well. I don't know if any of my fellow panelists would wish to add to those comments.
Right. Thank you, Kate. My next question is directed to Dr. Viswanathan. So this is with respect to sovereignty. This question says, there are concerns with respect to sovereignty of a country that cross-border insolvency may expose one country to its professionals to legal process and decisions of another. This is regarded as having the potential to subordinate national interest and institutions to foreign influence, with a consequent loss of ability to regulate one's own affairs. What are your views on this, sir?
I don't agree with that. There's a lot of confusion in this because the question, it works both ways. The foreign representative who comes to India will be subject to our jurisdiction. So when our people go there, they're subject to their jurisdiction. I don't think this is any issue of sovereignty involved here. It's a cooperation, mutual cooperation, and I don't think that is the serious issue.
Right, sir. Thank you. I believe we are falling short of time. Maybe one last question. This question is directed to Kate. You covered on public policy angle on the subject matter as a break in a jurisdiction, but do you think that the concept is infringing on the rights of stakeholders of a particular country and the company exposed to shall be failing in its obligation if subscribed to? Should I repeat?
Sorry, I think it would be helpful if you could repeat the question, if you wouldn't mind.
Yes, you covered on public policy angle on the subject matter as a break in a jurisdiction, but do you think the concept of public policy is infringing on the rights of stakeholders of a particular country and the company exposed to shall be failing in its obligation if subscribed to?
I hope what came clear from my comments is that the public policy exception in Article 6 is really meant to be a very, very extraordinary circumstance. And as we've seen in the case law, has not been invoked and has not been necessary. And part of the reason for that is there are many, shall we say, built-in protections for creditors and for the other interested parties in the model law itself. So judges have quite a large amount of discretion to protect the interests of those stakeholders. So I don't think that there is a problem in terms of public policy. I don't know, perhaps I haven't completely grasped the question, and perhaps Judge Gropper has something that he'd like to add in terms of the public policy exception, since he's actually dealt with that from the bench.
Well, I don't think that the exception or the law, let us start with the law, infringes on local interests or on local sovereignty. As Dr. Viswanathan said, you, under the model law, you go to a nation, the foreign representative submits to the jurisdiction of that nation, but the model law has a specific provision that says that it's not a general submission, it's only a submission with regard to the application. And similarly, I think that there's there's enough protection for local creditors, both with regard to the public policy issue and even broader, the fact that they must receive adequate protection of their interests with regard to relief. And there's a specific provision of the model law that says that if you're going to take assets out of that jurisdiction and send them to the home jurisdiction, that local creditors must be adequately protected. And I believe that means particularly secured creditors. So they shouldn't lose their security by virtue of the Chapter 15 petition. May I make one other comment with regard to interim relief that I was thinking of as that was discussed? We look on an Chapter 15 petition as ancillary, or I think the English would say ancillary, to the foreign proceeding. In other words, it builds on the foreign proceeding. It doesn't create a separate bankruptcy estate. Therefore, since there is a foreign proceeding pending, perhaps the local court could grant relief, because the relief is really in support of the foreign proceeding that is already pending. So it's not as if one is granting relief before the insolvency or the bankruptcy has been recognized. It's been recognized if the case comes from India, it's been recognized in India, and for the US courts anyway, that should be enough, so long as we view the Indian system as one that is based on due process, fairness, and that is a system that should be and should be routinely recognized in the United States. And I believe it clearly would be, as it was in the Shapura Minikin case.
Right. Thank you, sir. Aparna, would we have scope for one more question? I see plethora of questions.
Yes, sure. I think one more. Yeah.
One more. Okay, so probably that would be the last question. And if I may request both Dr. Vishwanathan and Mr. Batra to share their views on this. Sir, one concern with foreign representative being able to access tribunals in India in connection with cross-border insolvency proceeding is that under Indian law, some foreign professionals, for example, the lawyers, are not permitted to practice in India. How can the spirit of model law on access of foreign representatives be reconciled with these type of domestic restrictions on practice?
This is a question which we anticipated. See, not only lawyers, other professionals will also come. It's a bar council which has misgivings. We expected that. You see, then we can always have a safety in the sense they should tie up with an Indian law firm or an Indian lawyer who is subject to Indian jurisdiction. They will commit, they will enter. We discussed with the Sumant Batra when we drafted that model law. So this can be addressed at a very different level. It need not be made into a big issue as a lawyer, foreign lawyers versus Indian lawyers. It should not be like that. It's very easily overcome because, especially when the other professionals are going to come, you can't bar lawyers from coming into India or Indian lawyers from going abroad. So there is an issue on which we had some talk, and someone may be able to throw more light on this.
Well, no, Dr. Vishwanathan, you said it. I don't also have any concern as far as the larger issue is concerned, because I don't really think that every foreign lawyer or foreign representative is wanting to appear in Indian courts. I don't think that's what their priority is. You would always want local assistance, and you will get it. My concern is slightly different, Advaita, and which is that. And which is what is bothering the government, and nobody has really discussed it with me, but in some casual discussions in the past, I had got a sense that their concern is that if a foreign representative, especially an officer, were to act in India in relation to an asset or in relation to a creditor and were to misconduct, then how would you deal with such misconduct? Where would the accountability be? How would you make such person accountable to the Indian law or Indian system, and what should be the mechanism for that. I think that is what they're grappling with, and that's where probably they will have to have a very cautious approach and take baby steps, because they don't really want to be in a situation where they are helpless and are not able to deal with any such instance which comes across them, where somebody has not followed the code of conduct or misconducted, because they will not be subject to the Indian regulatory regime. So I think that's where they're trying to find some answer, and I'm sure Aparna would probably be in the best position to speak. But although I respect also that she may not be able to share everything with us because the reports are still confidential, discussions are confidential. But maybe Aparna, if you would like to share anything
sure.
without. Yeah.
Sure, and this is something we've been debating a lot at the committee that's looking at the delegated legislation for cross-border insolvency, because one concern is how do we make sure that the foreign representatives are regulated to the extent that they need to be, but at the same time, I think there's a general consensus that this does need to be a very light touch regulation. It's not intended to impose a large number of other obligations on the foreign representative. The only issue should be that they are subject to the jurisdiction and the relevant rules and procedures at the time, of that particular case, when they are subject to those to the tribunal or to the case. So beyond that, I don't think the intention, and I also think this is something that will have to develop with case law. I mean, there's also a danger, I think, in regulating too much too early in this stage, because I think it's something where, the model law provides some flexibility, and we do need to see how, we need to adopt it and then see how these things pan out, because there could be judicial solutions to some of these issues, and we should also be a little careful about over-regulating that.
We certainly need an insurance industry, so that they have comfort, that they are protected, because that's so common in jurisdictions abroad, but we don't have a well-developed protection system by way of insurances. So that's something which would have to be naturally developed alongside.
Right. Thank you, Aparna. Thank you, sir. Unfortunately, we would have to conclude our session as we've already crossed our time. And with this, I would like to quickly conclude with a small thank you note. On behalf of UNCCI, I would take this opportunity to thank our illustrious panel, Honorable Judge Alan L. Groper, Ms. Kate Lannon, Dr. T.K. Vishwanathan, and Mr. Suman Batra. Your willingness to share your time and expertise in the area was critical for the success of this event. Today's discussion has clearly helped us gain a fresh perspective on the national and the international aspect on today's theme. I would also like to thank Mr. Gaurav Banerjee and Atitha Commander for being part of today's webinar and agreeing to deliver the introductory remarks. Further, would like to thank my co-moderator, Ms. Aparna Ravi, for the efficient management of the session, and a very special thanks to Mr. Ajay Thomas, Director, Manav Rachna University, for all his efforts and tremendous support for the webinar. And I would further thank UNCITRAL and especially Ms. Anna Jubin Brett, the Secretary UNCITRAL. Apologies if my pronunciation for the name was wrong. And would like to thank our organizers, UNCITRAL Regional Center for Asia and Pacific, and our another organizer, Center for Excellence on Alternative Dispute Resolution at Faculty of Law, Manav Rachna. Our media partner, Live Law and Rashid. Last but not the least, our attendees for their enthusiasm and participation. Apologies for the many questions that couldn't be addressed due to paucity of time. And this is UNCCI's 4th webinar in the series. And I would invite our audience to join us for our next webinar, details of which we would be available soon. Till then, stay home, stay safe, and have a great day. Thank you, everybody.
Thank you to you too, Advaita, for holding us together.
Thank you.
Thank you. Thanks,
Thank you. Thank you, everyone.
Thank you.
Thank you.